Uh, Hi everyone. Good afternoon. Can I use this? Okay. Thanks a lot for being here. Usually, you say that the last speaker between the audience and the meal is has to be short, and if you are a lawyer, you have to be shorter. Otherwise, people will get bored. And I don't have the appetite-inducing properties of cannabis, so I'll be quick. I know I have a mixed audience, people that know a lot, people that are beginning, so I'll address two topics. One is the key aspects of cultivation and production and access to medical cannabis from, of course, a legal point of view. And the second part, it will deal with CBD, as typically I'll get a lot of questions on CBD. So I'll divide the presentation between these two areas. I believe it's very important when we are dealing with cannabis to never forget where we come from in terms of cannabis, the regulatory context. And the regulatory context of cannabis is the opium framework for regulation. So every law that we have in the world, it derived from the effort of the international community in the beginning of the 20th century to regulate and to solve what was then seen, what was then called as the opium problem. And that framework, that governance system, those laws, those ideas, they started there. Of course, you all know that they then got a new speed and a new moral framework later in the 20th century. But the origin, the UN treaties, they all stem from the Opium Convention and from the Opium Convention and the first and the second Opium Convention. In Portugal, we had, as in many European countries, because the Opium Conventions were attached to the Treaty of Versailles, we had an early adoption of the laws. So the first law is 1923, but those laws had no provision on cannabis. They were silent on cannabis. But if we go to 1926, there's after the second Opium Convention, we see the change on the medical and legitimate uses language to a more restrictive language that we still have it on scientific and medical uses. And then we have, on the second Opium Convention, the introduction of cannabis called Indian hemp at the time. And then Portugal in 1926 added cannabis to the list and allowed for the prescription of medical cannabis. So when we hear and when we say that medical cannabis was approved in Portugal in 2018, that's not true. We have in Portugal in the legislation the possibility of prescribing medical cannabis since 1926 in the Portuguese legislation, with fines, with bookkeeping obligations for pharmacists, etc. It's very interesting. I don't know if cannabis was or not prescribed, if cannabis tinctures were or not prescribed. That's something for pharmacy and medical historians to do. I would love to do that, to sponsor that, but I don't know the answer to that, but it was in the law. But there was no rules on cultivation. So as I'll address some rules on cultivation and manufacture, there were no rules on cultivation. So legislation had rules on cultivation for opium, that came from the Opium Conventions, but no rules for domestic cultivation on cannabis. We have to fast forward to 1970, when the Portuguese government started to amend the drugs legislation. So it was, for those of you who are not Portuguese, we had a very far-right regime, a dictatorship. It was the times of also the revisions of the conventions at the UN level, the war on drugs, and Portugal revised legislation and introduced, and I also don't know the reason to that. I believe it's related to Portugal having extra metropolitan territories at the time in Africa, but the possibility to cultivate cannabis was introduced in the law. It's very funny that I'm not sure that Mr. Marcel Caetano, the dictator at the time, was aware of that, but it's very funny that the decree law is 420, the decree law that allowed the cultivation of medical cannabis in Portugal. But it's there. So that's when we have the first legislation that allowed companies or individuals to allow to bid or to apply for a license to have cannabis. We don't have that. We don't have that practice until 2014 in Portugal, when the first license was awarded. And the first license was awarded because before that, international companies looked at Portugal to grow opium. So in the 2010s, around that, after the boom of opium production in Spain, legal opium production, Portugal became on the on the radar of private equity funds and international money. A little bit of what we see now with cannabis happened on a very short period of time with opium, with poppy seed. Spain was quicker in terms of granting more and more land to Alcaliber, so it was not profitable to grow opium or to manufacture morphine in Portugal as it is in Spain. So those facilities, I think, they closed or are about to close. And after that, the cannabis industry started in Portugal. The first license was awarded to GW Pharmaceuticals. GW Pharmaceuticals set up an operation in Portugal to grow or to study at the beginning of the operation for Sativex and then Epidiolex, and then it changed a little bit the route because due to FDA requirements for seeds and other stuff. And you know that story. The definition of cannabis is in the single conventions, and then it's adapted by the domestic countries. We know that cannabis means the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves when not accompanied by the tops. If we go to the Portuguese drug legislation, we see that the leaves are included in the definition of cannabis. Therefore, we have a more restricted in terms of plant definition of what cannabis is. And then in a nutshell, what the conventions, the international conventions say is that the parties, meaning the countries that sign the conventions, should take all the measures to control the uses of the substances scheduled in four schedules, in 4 lists. And cannabis is listed both in Schedule 1 and Schedule 4. That may change in March in Vienna, in the beginning of March in the CND convention, but up to today, Schedule 1 and Schedule 4, that's the strictest form of international control for a plant. Article 28 says that the parties, the member states, may allow the cultivation of cannabis, but they have to restrict it. If we go back to the beginning of the convention, the 61 convention, the convention said, okay, there can be other uses for cannabis, but in 25 years we should eradicate cannabis from the world. That hasn't happened. And Article 31 has, which is very important for a country like Portugal, measures on the international trades of cannabis, meaning what's the system for importing and exporting and transiting cannabis plant extracts and oils from one country to the other. It's important to remember, if you are thinking of investing in Portugal, already investing in Portugal, that the fact that Portugal is a country of the European Union is more or less irrelevant for the international trade of cannabis, because international conventions will apply stricter than the rules of the European Union. Otherwise, you could plant cannabis here and bring it to Spain or whatever, as you do with tomatoes or with grapes, and that's not the case, as you know. And don't try to do that. Okay, some key aspects. This is the 4 most important regulations on Portuguese cannabis: the Decree Law 1593, the drug law, where the exceptions have always been for the cultivation and use of drugs; the Regulation 6194 that regulated those laws and that has been amended since then; Law 33, 2018, the Medical Cannabis Access; and Decree Law 219 that divides between medications, preparations, and substances, but says that medicine law applies. We'll see some aspects of this. We have 5 types of licenses for cultivation, production, fabrication, and extraction. The concepts are not very clearly defined in the law. You have to go back to the treaties. The cultivation is cultivating the plant. That's very easy. Then production, fabrication, and extraction. Extraction is easy. The borderline between production and extraction. Production means when you bring the drug from the plant, when you take out, when you separate the drug from the plant, which is sometimes not very obvious when that happens or not happens. If the plant is not flowering, doesn't have THC, it doesn't matter because both international domestic law and international conventions, they don't exclude non-THC plants. We'll go back to that when we speak about CBD, but that's very obvious. When the conventions were approved, no one knew what was THC or CBD or whatever. In 1916, no one knew. Even in 1961, there was a huge ignorance about the components and the cannabinoids and even the cannabinoid system at the time. We have three purposes for any of these licenses: the medical, veterinary, and research. One company just got a research license. I'd be curious to know what the research license includes. Then there's the medical, the big one, and the veterinary, which so far I don't see any company trying to go that way. The authority to grant the license is the Infarmed. It's the Portuguese medical regulator, medicine regulator, which has now set up an Office of Medical Cannabis, which is an obligation deriving from the UN conventions that finally set up. And Infarmed will consult with other government agencies, with CICAD for the good standing and moral standing of the company owners and other entities if needed. And now we have, which is not stated out in the law, but we also have, if you want to cultivate cannabis, you have to have a declaration from the mayor saying that he does not oppose the cultivation of cannabis in the area of the municipality, which is something that may one day see the light of the law, but now is only on a piece of paper, or at least published by Infarmed. Which it doesn't matter, but if you want to go strict legally on that, it's a requirement that's not in the law, so it's a requirement that companies don't have to abide with. But of course, no one wants to grow or manufacture cannabis having the mayor against you, so it's irrelevant. If you go into a municipality, you'll have that letter. Some of the requirements: you have to have a chief pharmacist with full-time employment contract. That's a doubt that clients always have, if the contract should be full-time or not. Then you have to pass the fit and proper test for moral and professional of owners, supply the criminal backgrounds checks carried out by the Portuguese authorities, also for the company. No one knows where those background checks stop. If you are from a country with multiple criminal offices, what do Portuguese authorities want to see? Do they want to see the federal criminal record, the state criminal record, the places where you lived, where you grown up, if you have smoked a joint when you were 16? No one knows that, so it's a little bit of a trial and error. The time to license in the law says it's 60 plus 30 days, but the reality, you all know, it's greater than that. In the law also says that if any of these licenses is denied, you can appeal. Licenses are issued for 1 year. They are renewable, non-assignable. The license is non-assignable. The company can be sold, but the license is non-assignable. I know that Infarmed is starting to look at change of control as an issue. Of course, that all regulatory assets need to have a regulator that looks for change of control of the company, because when you say that the license is non-assignable, you should look at assigning the companies that own the license, and I hear that that's now being done, and they should be published in the official journal. Now Infarmed started a website where they list the licenses that have been issued. Once granted, this is important. This is important meaning that this is non-common in terms of license. The regulator has extremely broad powers to inspect, enforce, and revoke. Of course, this is due to the framework and to the fear of diversion, to the fact that we are operating with international controlled substances, meaning that no country, and Portugal applies the same type of broad powers as other countries. No country wants to grant a license to manufacture or cultivation, and then cannabis or other substances ends up in the street, in the school, or whatever. And therefore, it's very broad. This is non-typical. When you have an authorization to do something, there are more limits to the power that the entity that authorizes you will go. Then you have to have all the industrial requirements, the industrial licensing requirements, of course, building permits, etc. And as you all know, you have to apply with the good practices bit of cultivation, manufacturing, and distribution, which is, of course, easier said than done. That's not a legal question; it's more regulatory and quality issue. And as with all the rest, but especially here, being a very recent and new field, it's prone to doubt, it's prone to overinvestment, but it's also prone to fraudsters and scammers. The regulation of access. So in Portugal, although we had that legislation from 1926 allowing the prescription of medical cannabis, we didn't have, of course, as you know, a program of medical cannabis. And it was a little bit awkward that we had cannabis investments in Portugal to treat patients in other jurisdictions, and we didn't have anything done or any evolution in the field for the Portuguese patients. And therefore, Parliament approved legislation to allow the medical access of cannabis. That's typically the way things are done in Portugal, rather than through courts, as it happened in Germany, as it happened in Canada, as it happened in some of the US states, as it's happening now in Brazil. In Portugal, courts don't change policy. Courts apply the law, which is good and bad, but it's a different legal system in practice. We don't have those types of patient-induced change in legislation. You can have patient lobbying, but you don't have courts siding up with that. So the Parliament did that. Bloc de Esquerda took the lead on that. Many of the people that spoke here and are here were very important in that process. The law was approved. I'll touch only 4 subjects. The Portuguese legislation, especially the regulation, more than the law that was approved in Parliament, which the farm industry tried to a little bit, or I don't know if tried, but to boycott. But the regulation is very clear. In Portugal, we have 3 categories. We have medicines, and you can read Sativex, Epidiolex, whatever. So normal, classical medicines, tests, clinical trials, FDA approval, EMA approval, normal path to market. And then there's preparations and substances. And preparations and substances, and the plant is expressly recognized as one category of medical cannabis. And this is very important, because it's very important that the law is clear, because then regulators, government agencies, and business entities will not, or at least would not make the same question 100 times if a flower in a jar is a medicine or not. The law says that the plant is in itself a medicine. Therefore, as a different category, the requirements to access the market are different and lower and appropriate, let's say, appropriate to the fact that it's a plant, than the medicines. This means that you don't have to pass the clinical trials, but of course, but of course, companies should prove the safety of the substances and preparations with the existing literature and the existing scientific research at the time. Then Portugal did something stricter than other countries, which is listing the conditions to which doctors can prescribe medical cannabis. This is a very bad aspect of our legislation. Not only the list is small, but probably not appropriate to what patients and what the sector would wish. There is neuropathic pain as something that can have a broader use, but the rest of the conditions are so strict that this Portuguese medical cannabis program will never see the scale that needs to be even amended to each side. So it cannot even be a test if pain doesn't allow for or will not lead for a broader prescription by doctors. But the fact that there is now regulation on medical cannabis means that medical cannabis companies and products have to comply with many of the norms that are applicable to traditional medicines. Pharmacovigilance, marketing. So it's, when you get into the legal side and the regulated side although it's not a medicine, the law is very clear that when it's not, when the regulation can apply, the fact that being a plant does not forbid the regulation to apply, the Traditional Medicines Act will apply. This means that pharmacovigilance obligations, marketing authorization, so you cannot have marketing of medical cannabis, you can have marketing of legal, you have to apply the same rules to market medical cannabis as to market an antibiotic or whatever. It's the same rules. So this is important for the industry to understand and to move that. And then there's pricing. We have a small regulation on pricing, saying that companies should notify the pricing to Infarmed. Infarmed can oppose if the price is too exaggerated. And the regulation also says that in a while we'll move to the maximum pricing regime. This is one thing. The other thing that's probably starting now the debate is what will happen with the co-payment of the state. We don't have an insurance system like in Germany, but there are some co-payment from the state. What will that be? The sector has not pushed for that so far. No one wants to have a tabloid press saying Portuguese taxpayers' money is paying for cannabis. But now that cannabis is there, that the legislation is there, that's a conversation that everybody is willing to have. And the government, having limited to such strict conditions the use of medical cannabis, will have a hard time saying that there's no co-payment. They would be in a better position if the list was very open and they could say, no, I don't want to co-pay a medical cannabis just because someone is tired. No, but these conditions are so strict that's very difficult to avoid co-payment. But that's a discussion for the next year or so. So what are the most uncertain points of all this? I would point five aspects that I like to address. The first is the so-called pre-licenses. Every time I go to a conference, and I've been speaking in a cannabis conference for the past 3 years now, on almost a monthly basis, and I've seen more Portuguese cannabis licenses than probably there's cannabis plants in Portugal. And plants not as a factory, plants as a seed and the leaves and the stem. Meaning there's a huge, let's say, a huge exaggeration of what's happening in Portugal. Now it's going to go down as Infarmed listed on the website that there are only 4 licenses. But then, because Infarmed is taking too long, these pre-licenses, these so-called pre-licenses started to appear, which are only a document issued by an entity saying that the documents provided are okay. But I've seen many times people trying to buy and sell and asking my opinion on what that is. As a lawyer, pre-licenses do not exist. They do not exist. They don't have any legal value. They can, in the limits, if the regulator will then say, no, but I don't agree with your business plan in total, or you cannot go to this region, can give rise to some kind of liability based on legitimate expectations, but you don't want to have that fight. Because when a court will decide on that, cannabis will be legalized all over the world. So courts take a long time to decide in Portugal. You don't want to be there. So there's zero legal value on a pre-license. Then the second problem, which raises a lot of uncertainty to the market, is the express introduction on Article 22 number 3 on the possibility of Infarmed creating, on the basis of public health and international requirements, a cap on cultivation, manufacture, import, and export of cannabis. That would always derive from the conventions, so that's not new. That's something that was already on the conventions. That was in the drug law, but now it was made very clear in the regulation. I don't believe this changes anything, but that power is there. It was already in the convention, so it's not new, but that power is there. The UN conventions also. Something I didn't point out, but the UN conventions have a governing system. That governing system is presided by a body called the INCB. The INCB oversees how the treaties are implemented, but the INCB and the UN, they don't have any power over the countries, any legal power. So the UN cannot say to Portugal, you are exporting a lot or not a lot of cannabis. They can say that, but they cannot restrict the amount of cannabis. They cannot set quotas. The countries have to communicate to the UN their estimates. They can amend their estimates, but there is no legal infringement or no legal fault if you go below or above your reported estimates. You can always correct that. And in the UN, the INCB issues an annual report. They can make a rebook. They can say, oh, Portugal is over-investing in cannabis, as they say with opium in Spain, as they say with opioids in the US, as they say, of course, with Canada, Uruguay, as they said with the Portuguese decree policy in 2000. They can say whatever, but they have no legal power. Of course, that countries vary in terms of how compliant they want to be with the UN, how they want to be seen. If you are a small African country and you got a lot of money from the UN, you don't want to have a rebuke by the UN. If you are a traditional compliant country, you probably don't like that. If you are a country with Canada, like Canada, they don't care what the UN says. Or like the US, but I don't see the US now going this way, but it would be fun to see. Then we have in Portugal the mysterious case of the missing portaria regulation. There's a regulation that will probably come any day, yesterday, tomorrow, in 1 year, no one knows. That's foreseen in the law, which will put in the law the requirements for cultivation and extraction, also for other other uses of the cannabis plant rather than the medicinal, which is important for the hemp sector, for the CBD sector. But that regulation is not there. What we hear is that regulation will try to codify what is already said to companies and to players in the industry, but we have to see it once it's there. That I would be aware of two movements that are happening at this time in the world. The first is the vaping crisis. No one knows how the vaping crisis will affect the cannabis industry. That's one thing to watch. In Portugal, we believe that the smoke form of the plant will not be forbidden. It's not forbidden in Germany. Sometimes Infarmed says that in Germany it's forbidden. It's not forbidden. It's of course non-advisable, but it's not forbidden. And if you speak to any German patient, you'll see that that's not forbidden. But this is new. The vaping crisis is new. So how will that impact medical cannabis in the European market? That's one thing. And the second thing to watch in a more positive way is the international trade developments. So what will happen in terms of regulation, of course of market, but also of regulation for the global supply chain of cannabis. Will we have regulated global supply chain of cannabis or not? What will happen with the countries that have production that are lower cost and better climate to produce cannabis? Will they be able to export in a way that's not something typical of the 1912 and 1950s? Something more appropriate to international trade? Will countries move and try to come together with a solution for the barriers to international trade? Because asking for import and export permits from drugs regulators to move one plant or 1 ton of plants, it's not what the market expects. But of course, no one knows how this will go because no one wants to create, no international institution wants to legitimize a global supply chain that can or could be used for non-medical uses. So that's the problem. Okay, so I have 5 minutes. I'll go very quick on the CBD problem. I'll go on the problem and then what I think could be the solutions. So CBD is picking up the interest on CBD. I did a research on Google Trends. In September 2017, CBD searches surpassed THC, and in September 2018, CBD searches surpassed omega-3 searches in Portugal. This is Portugal. This is not other countries. This is Portugal. This is really, really interesting. Currently, CBD searches are 6 times higher than THC searches on Google in Portugal. So this means there's a craze about CBD, as we all know, and this has some impact on what's happening. Courts and regulators all over the world are being faced what to do with CBD. Companies are coming up with the strangest and non-strangest uses for CBD, from tampons to dog food to bath salts, both medical nutraceuticals, healthcare, veterinary, and food. And no one knows what to do with this. I'll skip some slides, but I'll say that the problem with CBD is this. Cannabis and THC are controlled substances and narcotics. That's the beginning of all. If we go to the conventions, to any domestic legislation, THC and the plant is scheduled. Second assumption, CBD as such is not an explicit controlled substance. So the plant is, THC is, CBD is not. But CBD is present in parts of the cannabis plant, and the plant is scheduled. So that's why I started with number 1. And both in low THC and hemp and high THC cannabis. Then fourth piece of information to make this more difficult. Historical cannabis plants with THC below a certain percentage have been cultivated and have been having allowed uses. We can call it hemp for simplification, for fibers in other industrial uses, or in some countries like Switzerland as tobacco substitutes. And then the fifth point that we should never forget is that the intended uses of CBD, of each company, the intended uses of the products that regulators have to look at, that lawyers have to validate, are highly regulated, even if it were not made from CBD. So it's not the fact that CBD that makes the regulations disappear. And so if it's healthcare, you have regulations for healthcare. If it's food and food supplements, you have regulation for food and food supplements. If it's cosmetics, you have regulations for cosmetics. Once I had a client coming through my door that they wanted to grow CBD, and of course I don't know how to not lose time with this, and I only asked one question: what's that CBD for? And of course they were smart, and they said that's CBD for CBD. The use of CBD would be CBD. That's it. That's a good one. But you should never fool your doctor or a lawyer. That's not okay. Okay, if it's what's happening now in Europe is that the European Food Safety Authority, so food supplements are food, are treated as food. And to be able to sell a food that was non-existent in Europe in March, I always get this wrong, 1995, or in Europe before, you have to be in a, you have to have a procedure for a novel food, to be authorized. Like if I find out the seeds that were never eaten, I have to go through this procedure, a little bit like the medicines if you're not in this space. And the food, this is very interesting. The definition of food by European food law is food or food substance means any substance or product, whether processed, partially processed, or unprocessed, intended to be or reasonably expected to be ingested by humans. It's very interesting, this reasonably expected definition. So it means something that's intended to be, so you are claiming, you are selling, you are marketing it, you are putting in something that people, that you want people to eat, or reasonably expect it to be because of the packaging, of where you sell it, where you put it, that's considered food. And if the food is a novel food, there's a procedure for novel food. And of course, the industry tried to put CBD as a food supplement in everything. And then what happened is that the regulators went back to this conundrum, meaning, okay, CBD is not listed, but CBD comes from a plant, and the plant is listed, is scheduled, is forbidden, let's say like that. And the industrial uses that I allow in my country is roads for the ships to sail. It's not, I don't know, soup supplements or whatever, calm night CBD. And therefore they didn't know what to do. So now we have the EFSA looking at this, and since January the Novel Foods catalog was amended. So it's a catalog, it's a description of substances, and no one knew if CBD was there or not. And in January 2019, it was amended to be very clear that CBD is there. No doubt that CBD is there. So in short, seed oil, seed flour are not novel foods. Cannabis flowers and leaves are novel foods. Hemp extract is a novel food. CBD isolated, that's the important part. CBD added to foods or enriched to enrich food is a novel food. This means that to be allowed to be legally sold, we have to wait for a decision on that. And the problem is that, unlike medicines, it's difficult, or it's not a clear path to have rights around, property rights around CBD, around discovery around CBD. This means that no company wants to invest, what I hear is about maybe €500,000 or 300,000 euros to get CBD on the novel food catalog, and the day after you have 1,000 companies selling and claiming CBD because it's in the catalog. There's a way to protect your rights for 5 years, but that's very, very, very difficult to have and to prove. The European Hemp Association is lobbying and is fighting this, is trying to say that people were eating hemp plants and CBD from the hemp plants for hundreds of years. I don't think that will go anywhere. I don't think that the EFSA will be convinced by their arguments that there's I don't know, muffins received from the medieval Italy in a cave that people were eating. I don't know. I'm not a food supplement expert. I work with food supplements, but I'm not an expert in fighting EFSA. But I don't believe they will ever do that. And even last week or a few weeks ago, the German government said very clear that either medical CBD is medical and there's medical cannabis legislation, or they will wait for the EFSA to decide on the novel foods. And Portugal will do the same. Courts in Sweden have said that. Courts in Italy have said that. And just to remind everyone, the fact that we can go to a nature shop and see a CBD flask or the CBD whatever, it doesn't make it legal. Just makes that it's there. It doesn't make that what I've said is not. Okay? Okay, I think that just to... Okay, we can then answer the questions.
Applause?
Yes, thank you very much. Fantastic.
Please have a seat. Yeah. Before the questions, I remember we found a ring. It's black and looks... So if it was on the toilet, so it will be there. There you have, you can clap.
Right.
Thank you. Let us remind you of the surveys. Please answer the surveys, rate the speakers, it's really important. And now, before closing, and the closing session, some questions and answers. We have one question in the app so far, right?
Yeah, one extraordinary
It's from Mr.
question.
Michael Miller.
Michael Miller has a question. Trying to trick you. Excellent presentation. What do you think are the political reasons for lawmakers to play doctor in Portugal and create a list of improved conditions? Doesn't this defeat the whole material part of the reason for legalization?
Yeah, I think so. And it was a risk that even the first list that circulated didn't even include child epilepsy. So we would be in a very strange situation where the fact to amend legislation, the kids with Dravet or other forms of epilepsy would not even be covered with the law, and that to be a shame for the Parliament. That changed, and that is there. But it's very strict. And so the government, what they the Parliament and the government, what they did is they wanted to be strict. They wanted to pass the legislation. They heard all the opinions and all the advocacy from the pharma sector, and they did the strictest of legislation, which means they went to the countries which had lists, which is, I believe, Ireland and the Netherlands. but they did not include an open clause in the list, in the Dutch list, that says doctors can prescribe if, to other conditions, if this and this and this, which is of course an open door. What they did is said that Infarmed can update the list, and therefore the list can be updated. But I think that's up to patients to show that the law has been passed, and no prescriptions or few prescriptions will be made in Portugal. But also what I have to say is that there's a lot of education that should be done still to doctors and to patients, because here we are all educated, we are all converted. Many people have studied, they've suffered, they've prescribed, they've used it, or are in the sector for business reasons. But out there, people really don't know. And the law has a provision. When I speak in public, I always make sure I mention this. The law has a provision that says that the government will invest in the education for medical cannabis. So it's up to patients' associations, companies, universities to go there and ask Infarmed what money is there for this. Is it in the budget? We are now negotiating the Portuguese budget. Will that money be included? Who can claim for that? Who can grab? It's up for grabs there.
I see.
And even if it's a little money, it's more than nothing. But education needs to be done.
Do you think there's the chance of liberalization with respect to the definitions of conditions that will be available? Will it be open to stakeholders and listening to advocates or doctors to increase those conditions?
I really think so. The way the law is written is very difficult to go away with the list. What I believe is that the list can be expanded and include some kind of a more less scientific definition of conditions. Even the concept of conditions can have various interpretations. So I believe that's the way to go.
Great, thank you. Carla, do we have another
There's another question in the audience. Yes.
Olá. Gostaria de saber se existe...
I'm going to ask you a favor. It's step by step. Vou pedir favor, dizer frase a frase para poder traduzir para quem não fala português.
Tá bem. Eu gostaria de saber
I would like to know
se existe algum respaldo legal para pacientes, algum respaldo legal, uma proteção.
Okay, if there's any legal protection
Sim, para pacientes que já faziam uso, né, do CBD.
for patients who used to use CBD before.
E aí depois, como foi legalizado e regularizado pelo Infarmed, e ela listou 7 patologias, e esses pacientes, obviamente, né, não tiveram mais acesso tão facilmente ao medicamento, até porque o preço que hoje é praticado no mercado, eu acho que é um pouco alto, que gira em torno dos 450 euros do Sativex. Gostaria de saber se há auxílio a essas famílias, esses pacientes.
So the price is very high, and you want to know if there's a help for the families for the price made today for the Infarmed medicines, right? If there's any participation, that's the question?
Na verdade, a minha pergunta eu quero saber em questão legal, de proteção às famílias, no sentido de, por exemplo, se eles tiverem que fazer uma importação, por exemplo, para continuar fazendo. Eu vou dar um exemplo do Brasil.
Mas vamos fazer assim, porque senão depois é muito difícil de acompanhar a tradução simultânea. A pergunta concretamente é se há apoio às famílias, é isso? Na importação?
Exato.
Okay, so the question is there any support to families in importing medicines from abroad? And now we get the answer.
So what happened in Portugal, and it happens when you move an area, a sector, to become regulated, is that now it's regulated. And therefore, families that want to have prescribed CBD, they will have to go to the medical cannabis path. And that's what happened. I know it changed the quality for some people, for some business, the quality of life. They were used to having something that was on a gray zone. But now that's regulated, that's not possible. If you want to import CBD, CBD is a medical cannabis product. It has to be registered here, and you cannot import it directly. The companies have to follow the path. So I know that some people were using products, and those products now have a legal path. But I also want to believe that these families are more protected as there's more safety control on these products, and that's better. I believe Arnold touched on that in the morning. If you all the studies that show what the CBD products shelves in Europe have, many of them don't have CBD. Some of them have THC. Some of them have bacteria. Some of them have heavy metals. So we want to protect persons. I understand there's a transition period where people could use their good CBD and they were used to that and it was good for them and for the kids. But now you have to tell those companies if they really have a good product to go the way to ask for authorization and to have the market introduction authorization and follow the path as other medicines as you do with other type of medicines. What is very difficult is to sit with the regulator government entity and saying this is good because it treats cancer, but this is not a medicine. And that dialogue is very difficult. Even if you say it's a medicine, the parliament told you, okay, now there's a law, there's a path. You can lobby to try to make it better, to advocate, to put patients up front, but you cannot have no one can have the best of both worlds, meaning this is a medicine, but this is not a medicine. It's slightly, we say, sol na era chuva no bal in Portuguese, I don't know the translation in English.
Give it a try.
No.
No?
The best of both worlds.
Okay.
Yeah, the best of both worlds.
That
Well,
was pretty well.
So right now, I think we're about to reach the end. We'd like to ask your help now because we were asked one more question. We can do one more. Oh, there's a lot of
Is
questions.
it okay that we have 3-4 more questions? Can we answer the questions? 5 minutes? Okay, great.
Okay. Anyway, we remind you that if you place your questions in the app, it's not only more efficient, but you will get answered after the debate. So let's go for the next question. Please be brief on the question so that we can have quick answers. Where is the question?
Considering the patient necessities
Yes.
and the price that was here mentioned, and companies to produce, for example, CBD products, not by a synthetic way, but by isolation, and through a process like using sonification and CO2 superfluid extraction processes. These kind of products that with low doses than Sativex or Pedialex, so that would have lower prices. Where do they can match in terms of license? Because as far as I know, because of the extraction process, they cannot be botanical extracts and preparation, pharmaceutical preparation. And because of the doses, perhaps we cannot prove by trials the efficiency of the products. So where do they...
Yeah.
I answer now?
Yeah, please.
But the fact that you have that CBD extract is considered cannabis medical cannabis substance because it's a preparation which is an extract from the plant. You don't have to have clinical trials. So the Portuguese law allows for that. You have to tell which is the doses, which is the form. But carbo, I don't know what process you are thinking of, but I don't think that would be a problem. But you have to go the path for the marketing authorization with your product. You cannot not go with the path to that. But this is not botanical medicine. This is the law created a new box, let's say like that.
Can I remind you, please?
You don't have to go
We still have one question in the app. We have people asking for questions, so maybe you can read the one on
Okay, the last question in the app. And
Yushchenko. Yeah.
we want to answer all your questions, so can you please ask your questions in the app, and it will be answered by email to you directly, or you can meet him right afterwards. We have another question right here, okay? Once somebody gets an F approval, will it create an opportunity to sell CBD with approved characteristics to anybody, or just to the company that conducted the research?
If they don't apply for the special 5 years grant, it would approve to anyone. I think that's the problem of the incentives. So if you don't apply for the special protection of the way you do the CBD, it's like with what happened, I think, with the goji seeds or the chia seeds some years ago. Once it's approved, bam, all the companies can do it. And then It's medical supplements. Countries are not going to invest a lot in enforcement, going to the shelves and taking it out. So that's my interpretation of why it's not moving faster. What I believe is there's a Czech company that approved, that applied to the novel foods. Now the first toxicology results came bad, so they have to step up and do a different and a more broader tests with the product. As you all know, CBD is not neutral, so CBD has some toxicity, as all cannabinoids have it, which means that now let's see what the FSA says about it. Thank you very much.
Thank you. Before closing,
a brief announcement.
I think we have
First
closed.
of all, thank Joe very much.
Yes, but we would like also.
Thank you, sir. Thank you.